petition I have 5 minutes on 15/7.
What?
4 minutes is regarding the election of a Manipuri Sahitya Sangh.
Mention before the senior court. Bench fight.
Your lordship is today.
No. Today I am not more a senior. Nice. There is a senior bench.
70.
Wait, please, your lordship. Lordship, item number 19, in last date also, we have short time for negotiation, lordship. And lordship, we are both praying that it can go for mediation, lordship, because we are trying to solve the issue.
You want the matter to be referred. That's mother, daughter.
Yes, that.
That he says that the mother had given him a no objection.
He says that.
Whereas you say that there was no occasion.
No occasion.
And the learned Revenue Board has said that the mother being in possession, you all are said to be in possession. That's the...
And that way, everyone should get. Our contention is that we are not the only one. Everyone.
You are agreeable to go for mediation. Okay. We'll pass the order when it comes. We'll record your names. Okay, we'll pass the order. Heard Ms. R.D. Mujumdar, Learned Counsel for the petitioner, and Mr. J. Das, Learned. You are not there.
I'm only to say.
Mr. J. Das, Learned Counsel, appearing on behalf of Mr. S.P. Roy, Learned Counsel for the respondent number.
Respondent number 5.
5. Full stop. The Learned Counsel for the parties have submitted that they have arrived at a consensus to have the matter resolved by way of mediation. So the Learned Counsel for the parties have submitted that this court would refer the matter to the Mediation Center, Guwahati High Court, for a resolution. Full stop. In view of the above consensus arrived at by and between the parties, this court directs the parties to appear before the coordinator, Mediation Center, Guwahati High Court, on
As lordship.
On 1/8/2024.
Lordship, 1/8, I have other mediation because there is a trial going on.
4/8/2025 for taking the matter forward. Full stop. The coordinator, Mediation Center, Guwahati High Court, shall appoint a mediator for mediation of the issue arising in the present proceedings and shall take all requisite steps for having the mediation process conducted in the matter by and between the parties. Full stop. A report of the mediator be placed on record on the next after the conclusion of the process of mediation. Full stop.
Lordship, may like to fix a date for
appearance. I have fixed it on 4th. Raised it to list this matter again after conclusion of the process of mediation along with the report of the mediator.
Highly obliged, lordship.
Wait, please, your lordship. Lordship, I beg to mention item number 20 and item number 3, lordship. Lordship, we have also taken the consent of the
Item number
20 and item number 3.
3, why?
Lordship, my senior is unavailable due to some personal difficulty, lordship. We have also taken.
You are appearing for?
Lordship, P. Mondo.
Item number?
Item number 3 and 20.
3 is different. You are appearing for item number 8.
8, lordship.
8, huh?
8 and 20.
But this is a partnered matter. We had fixed it today for final hearing. What happened to Mr. Mohammed?
Lordship, not very aware, lordship.
We'll have it on Thursday. I've heard this matter. I've kept it today for... It's already a month now. I should not be keeping this matter like this. Okay. The matter was fixed today to facilitate Mr. P. Mohan, Learned Counsel for the respondent number 4 to make his submissions in the matter, in as much as the Learned Senior Counsel for the petitioners had already concluded his arguments. Full stop. However, a prayer is made on behalf of Mr. P. Mohan for an adjournment in the matter today on account of personal inconvenience. Full stop. What do you say?
Lordship, we agree with Thursday.
in view of the above, full stop, the prayer is not objected to by the learned counsel for the petitioner. Full stop, in view of the above, registry to list this matter on, again, on 29 fine? 29/8, 29/7/2024.
Lordship,
Oh,
may I,
pardon.
may I pray for another day, Lordship?
When?
Lordship, may it come on the 6th of August, your Lordship?
6th of August, on 6/8/2024. This matter shall not be treated as a further matter any further. I should not keep it for long.
So item number
20?
20, item number 20.
So a prayer is made on behalf of Mr. P. Mohanto, learned counsel. What? Here, whether that capillars have been fitted, what happened?
Yes, Lordship.
Fitted
Yes.
already. So now it's only with regard to the further compensation, if anything. Okay. Who is appearing for the respondents? Prayer is made on behalf of Mr. P. Mohanto, learned counsel for the petition for an accommodation, for an adjournment in the matter on account of personal inconvenience. Prayer is not objected to by the learned counsel for the respondents. Accordingly, the registry to list this matter again after 2 weeks on a date 2 weeks by. Capillars have been fitted.
Yes.
Okay.
May I please, your Lordship? Lordship, I mention item number 11, your Lordship. Here I put a petitioner, your Lordship. Lordship, the respondents have filed their affidavit just before the ensuing petition, your Lordship. We need 10 days time to file our rejoinder, your Lordship.
Now you are in trouble. You will have to get the orders of the court wherein your name, with reflection of your name.
That's what.
Otherwise, they have taken a plea that your name is not there. And your appointment order is also not on record. Why?
That I have made construction.
You are Mr.
Teach it, your Lordship.
Mr. T. Chetri, learned counsel for the petitioner, submits that an affidavit has been filed on behalf of the respondents. And he would like to bring on record a rejoinder to on behalf of the petitioners. Also, prayer allowed petitioner to file the rejoinder on or before 31/7/2025. Registry to list this matter again on 4/8/2025.
Much obliged, your Lordship.
After declaration for listing on petition.
Listing senior bench.
Lordship, can it be on any other day other than 4/8, your Lordship?
6,
7th, your Lordship, possible.
7, okay, 7.
Much obliged.
Yes,
Hello. The powers on the CPC has been conferred, my lord. Power regarding the injunction has not been granted.
I'm sorry. Here, it is only for the conduct of the proceedings.
Yes. So the exact point, I am also relying on a judgment of the Punjab and Haryana High Court.
But this goes against you.
No, I am not in anybody's favor.
Oh.
The correct proposition of law should be. In fact, your lordship. you
We are
correct.
thankful to you for that.
If I may assist this honorable court, Lordship, there is one more decision passed by a coordinate bench of this honorable court. It is not directly an injunction, but it says that if jurisdiction with respect to a particular subject matter is not conferred on the election tribunal, and if the tribunal passes any order to that effect, then the decision shall be non-est in the eye of law.
Page 20.
Para
That is-
27, Lordship.
Probably on a different point.
No, this is on a different thing. This is acceptance of a,
Yes, nomination, Lord, whether it could be challenged in a writ petition.
Yes, Lordship, the facts are different, but just the principle of law laid down in para 27. A jurisdiction with regard to a particular subject matter.
constitutional council. Constitution. Two 43K.
Yes. Of Article 4.
243, 4, sub 4. When is the date fixed?
Lordship 24. Day after tomorrow.
Can you serve a copy on the respondent?
Well, he is appearing.
Because
caveat.
you are appearing.
They have to
Okay.
be the caveat. of-
Yes, what do you have to say?
Submission is that Lordship, there is no specific provision in the statute for constitution issuance. Lordship.
There is no specific provision.
Specific, but as per notification issued under this section 127 Lordship.
Consider.
Lordship, this notification 2000. Lordship may have a powers,
Where? 127?
column 4, Lordship, not 27, this notification Lordship.
No. Notification is issued under section 127.
7 Lordship,
Okay.
in consultation with the High Court Lordship.
So let us see what 127 says.
Is what Constitution of Panchayat Election Tribunal.
Hmm.
The state, the government shall constitute such panchayat election tribunals as may be necessary on the recommendation of the High Court to dispose of all direct election petitions challenging the election under this act. The jurisdiction, powers and functions and the headquarters of tribunals shall be decided by the government in consultation with the High Court except as provided in section 10 of this act. 10 is regarding president of the president of government lordship. And by exercising this power lordship, this notification issued. 30th September 2000 lordship notification, laying down the power and jurisdiction lordship. And powers lordship may kindly have a column 4. Column 4 lordship, page 3, column 4 lordship. Tribunal shall hear the parties, examine such witnesses may be adduced, examine such documents as may be produced by the parties or obtained by the tribunal, and after hearing the tribunal shall pass such order as it may deem fit with reasons thereof, lordship. In this case, lordship.
So this is final disposal.
But in this case, lordship, there is prima facie disqualification, lordship. That is on record.
Plus 5 lordship also.
Plus 5 lordship.
Powers conferred.
The tribunal, while deciding an application under the act, shall follow the procedure of the civil code while trying a suit under the CPC.
It is only with regard to these because it's not a civil code per se.
tribunal.
So 151, order 38 will not apply.
Not so.
It is only for the purpose of these 5 aspects that the power has been conferred. So if that be so, where is the power to pass an interim direction? It may be an outright illegal thing, but interim will not be there.
Spirit of the CPC has been.
Spirit of the CPC subject to these.
It will make to differ between.
Yes.
If your lordship come to the procedure to be followed by the tribunal, the application to be filed under section 129 shall be in the frame of memorandum.
Where are you reading?
My lord, below the powers, my lord.
Huh.
Number 1, procedure to be followed by tribunal. My lord, with regard to the memorandum, grounds to be stated. And her application also read with 129, my lord. In a generally, what happened, my lord, any application filed under 96 or section 100 of the CPC, while filing with grounds and substance question of law, my lord, an application under order 39 rule 110.2 can also be filed, my lord.
I'm sorry, that will not come in. Show me the conferment of that power. Because you see,
My
to
lord,
come to the powers,
again 5, my lord.
5, okay.
The
Tribunal while deciding
an application under this
shall follow the procedure
of civil.
while trying a suit under so and so.
Yes, my lord.
As far as maybe in respect of the following matters,
No,
summoning,
procedure of
requiring.
civil court, my lord, in a civil.
No, it is again circumscribed. It is again circumscribed with the 5. If these 5 were not there and it was left at 1908, then everything would have 151, everything would have come.
Well, I do agree. As per my submission, he got the jurisdiction to, but while passing that order, my submission will be he has acted beyond jurisdiction. Because without giving him other side a chance, the final order has been passed with effect to the miscase. Otherwise, far my submission is concerned, my lord, since the procedure of the civil code while trying a suit to be followed, there is no bar in.
No, there is a bar. It can only be with these 5 aspects. It can only be with this 5 acts because it's not a court. Election tribunal, although the person designated may be a judicial officer 235, but he is not a court. So a power is to be conferred, enabling him for a adjudication to summon witnesses, requiring evidence, discovery, receiving evidence, these 5 aspects. So what we do is we interfere with this order. The election petition shall be considered in its own.
Within a time frame, lordship.
But that we will not take.
Time frame already by the least honorable court.
See, in 127, just for the jurisdiction power then functions and the headquarters shall be decided by the government in consultation. You know, that notification only empowers because of this power, 127.
Fine.
And it is the powers has been by incorporation, and incorporation is only in respect of those 5 provisions, not more than.
In a democracy, my lord, an elected person should not be barred from taking an oath.
The law is very clear that
is-
an election should not be interceded in the interim. Final orders can be passed.
Lordship, so far time frame is concerned, there was direct from this,
Huh?
and that direction may be given, so.
Expeditiously, that's all.
6 months time frame was earlier. Or not. Because my senior is also aware of.
He's not the repetitioner.
When is the next date fixed?
For oath taking lordship.
The tribunal?
Tribunal lordship, we have not received any notice. We don't know anything. And this particular order also, the impugned order, we got to know from the BDO because the previous date for the oath taking was scheduled on 17th. So at that point of time, we got to know about the impugned order having been
But
passed.
that, on that day, the oath taking had not taken place.
No lordship.
It is dated, not the order itself is different. Page 15.
Where do you find it?
Page 15, fixing 8/8/25 for SR and written objection.
8. Okay. Heard Miss Dr. P. Agarwal, Learned Counsel for the petitioner. You are on a caveat.
Lordship.
Yes, ma'am.
Where is the caveat? Also heard Mr. M.K. Hussain, Learned Counsel, appearing for the respondent number 1 on caveat. Also heard Mr. R. Dubey, Learned Standing Counsel, State Election Commission, appearing for the respondents number
Two lordship.
2. Mr. Doctor, you are not there. 4. Also heard government advocate. Mr. N. Das, Learned Government Advocate, appears for the respondent number 3. And Mr. S. Dr. Learned Standing Counsel, Panchayat and Rural Development Department, appears for the respondent number 4. Full stop. The parties to the proceeding have submitted that the present writ petition be taken up for final consideration and disposal. Full stop. Accordingly, the parties have made their submissions. Full stop. Upon hearing the Learned Counsel for the parties at length, the present writ petition. Full stop. The orders in the present writ petition. Full stop. I have heard the Learned Counsel for the parties. Full stop. Raised to list this matter again on Aji Baisno, 23/7/2025 for delivery of orders. I'll just go through it once, formulate and do it. Full stop. Caveat or liquidation. The caveat shall be heard at the time of disposal of the during disposal of the writ petition. Accordingly, the caveat stands discharged. You need not be here. We'll pass the orders tomorrow, 10:30.
You too, right.
I'll deliver it today only. 10:30, I will declare it. Anyway, we are interfering with the order. She shall be permitted to take oath and participate subject to the outcome of the. And now the matter is fixed on 8. We will request the tribunal to expeditiously consider and proceed subject to cooperation of the parties.
I'll place some orders fixing time frame. I'll place those. Time frame.
Not that it is.
They may have 100 and other cases to also look into. It's not only a election petition which is there.
And there
So
will
that
be
will
many
take
more
its-
blood, even election petition, one of blood. There will be others also blood. Now is one of the busiest courts.
Well, we can't restrict our judicial officers like that.
Keep to oblige, ma'am.
1, 3, 4, 5 disposed of. 2 CAV.
But 5 disposal.
Dispose of. We are interfering with your suspension order. But apply for your copies. It will take a day or 2 to get your copies.
I look at.
2 CAV, we'll pass the order next week. Pavone? 30 parties. at
Deeply
length.
obliged.
So and so, so and so. Next week, তাতে pilot আছে এইটো, সভাপতি কৰিব। Yes. এইটো মোক দি দিবা, এইটো কৰি। Must be, শিৱতে কৰিব। Yes, Mr. Bhuya, why the steps have not been taken?
My lord.
Steps not taken. 11, 12, 13.
Oh, my lord, actually, my lord, we have a written instruction, my lord, not to press further, my lord.
Press
Further, the petition, my lord,
this whole petition.
whole petition. My lord, may kindly keep this on
No,
record,
your statement is enough for me.
my lord.
Mr. A.R. Bhuya, Learned Counsel, heard Mr. A.R. Bhuya, Learned Counsel for the petitioner. Also heard Mr. H. Sharma, Learned Counsel, appearing for
1, 7 to 11.
1,
And
7,
7 to 11.
8, 9, 10, and 11. And Mr. A. Bhattaji, you are appearing for?
I am for revenue department.
Learned Standing Counsel, Revenue and Disaster Management Department, appearing for the respondents number 3. Respondent number 3. Full stop. Mr. A.R. Bhuya, Learned Counsel for the petitioner, submits on instructions that the petitioners have instructed him not to press the matter any further.
Right.
And accordingly, he prays that the present writ petition be permitted to be withdrawn. Prayer is not objected to by the Learned Counsel for the respondents. Full stop. In view of the above submission of the Learned Counsel for the petitioner, the present writ petition stands dismissed on withdrawal. Full stop.
Liberty may be covered.
With liberty to refile the same if any fresh cause of action so arises.
Right.
Full stop. Interim orders passed interim orders passed wide order dated 30/6/2025 shall stand vacated.
Obliged, my lord.
Yes, my lord, on behalf of Mr. B. Gogoi, I'm paying for adjournment of the day.
Why?
He's out of station, my lord.
Small instruction, you could have carried it. When was the policies applied and when were the other posts filled up? That's all. Then we will take a call on Mr. Khan's grievance. When do you want it?
Next Tuesday.
I can't proceed without this, Mr. Khan.
Fine.
Or you have any instruction on this?
No.
A prayer is made on behalf of Mr. B. Gogoi, Learned, Additional Advocate General, representing the respondents for an adjournment in the matter on account of personal inconvenience. First, prayer is not objected to by Mr. M. Khan, Learned Counsel, appearing for the petition. Accordingly, a registry to list this matter again on Kundina due 7/8/2025 as a part of matter. You'll have to wait for one more day. Yes. Have you got the records?
That is from my lord. Instruction had been sought, my lord, on the last occasion, my lord. It did.
Mr. Chaudhary, you are appealing for?
I am in the first writ petition. First writ petition, 4591,
Suren Talukdar.
Suren Taluk.
And Mr. Mannan?
He-
Student, respondent 7.
Now, he appears for the other writ petition.
Petition.
My lord, on the last occasion, my lord,
Who is appearing for the petitioner, Profulla Doctor? The report says that he is having a patta land, whereas you are occupying government land. Right?
Yes.
What do you say on that? Huh? Not hearing you.
My lord, Mr. Mandan is not there. today.
What happened?
So due to waterlogging, he would not come.
Oh. A pre-
Post it some other day, my lord. This
No.
presence is necessary.
His presence now would be more necessary. A prayer is made on behalf of Mr. Y.S. Mannan, Learned Counsel, for the petitioner in WPC number 7852/2018 for an adjournment in the matter on account of personal inconvenience. Full stop. Prayer is not objected. You are for the respondent number 6.
In his case.
Prayer is not objected to by Mr. D. Chaudhary, Learned Counsel, appearing for the petitioner in WPC number 4591/2016 and respondent number 6 in WPC number 7852/2018, and Mr. N. Das, Learned Government Advocate, appearing for the state respondents in both the writ petitions. Mr. Das, in terms of the directions passed by this court, has furnished the instructions received by him in the matter. Full stop. The same, however, is returned to Mr. Das with a direction to place the same on the next date of listing. The registry to list this matters again after 2 weeks on a date to be fixed by it. Mr. P. Nayak, Learned Standing Counsel,
GMD.
the GMDA is present.
List of the tradesmen.
2 weeks.
Can a date be fixed? If possible.
You make a mention, 2 weeks. It took very. You inform Mr. Mannan about the development.
Lord, that TV matter is fixed on 5th of August, my lord.
Fine. The act is no longer there. It's
No,
already repealed.
I have already given the act. Lord.
It's.
Lord, on last occasion, my lordship was also pleased to hear, my lord, regarding that the non-availability of the act. And then my lordship came to the conclusion, my lord, that as the issue is still, my lord, surviving due to the cause of action, my lord, which arose at the time of, my lord, while the act was governing. That's why.
Fine, fine. But now we cannot pass, it will be an academic exercise because the post itself is not there. Right? Now they have brought on record the repealing, you have only brought the bill, not the act.
Lordship,
Be that as it may,
Lordship,
the act has come in.
Yeah.
So you are no longer a appointee under section 3 of the Act of
Muslim
35. Right? Power was vested under that in respect of Kaji to register marriages. Right? You are not concerned with solemnization. You are concerned with registration. Now that act having been interfered with, although anything done under that act, fine. Now we cannot interfere with the order passed releasing you or any steps taken in your case. That has become rendered academic in view of the act itself going. So once there are decisions of the Supreme Court as well as our division, when an act is interfered with, anything flowing therefrom would not exist.
Then, my lord, may I submit, my lord? My lord, as per my lord, very limited and little understanding, my lord. When the act was there, allegation against me was that, my lord, I had solemnized and registered marriages of the Muslim minor girls.
That is a fact. That
No,
is a
that-
factual position.
That is a factual position. Basing on that fact, my lord, they are initiating a process for my arrest and police harassments are going on till I file this writ petition, my lord. When I approached before my lordship, in both the writ petitions, my lordship was pleased to pass interim order protecting me, relying on, my lord, that as the act given me the responsibility to register the marriage, my lord.
But then we'll take it up for final disposal.
Exactly, my lord, that's why, my lord.
Make your submissions.
Today, my lord.
Ah.
Lord, can it be taken up on Thursday, my lord?
Thursday, I've fixed up a lot of matters.
Then, my lord, on next.
I am
week-
ready with the matter. You
Lord,
can take a date if you want.
No, my lord, I have a little personal difficulty, my lord, today.
Heard Mr. A.R. Bhuya, learned counsel for the petitioners. In
Lord,
the
can it be fixed after 5th of August, my lord?
above noted writ petitions. Also heard Mr. J. Handick, learned
For extending
standing
up the
counsel,
revenue.
Revenue and Disaster Management Department for appearing for the state respondents. Mr. A.R. Bhuya submits that he be granted an accommodation in the matter today on account of personal inconvenience. Also, prayer is not objected to by the learned counsel for the respondents. Accordingly, the registry to list those matters again after 2 weeks on a date to be fixed by it. It will be after 5th.
May I pay for part one, my lord?
No. I don't know whether I'll be here in this bench. Why should?
Oblige, highly oblige.
But it was an interesting topic. I had invested some time yesterday.
My lord.
Your case is simple. Your case is the 1935 Act does not provide for a bar to register a already solemnized marriage.
Exactly.
You're only required to register.
Right, Kabir.
So whether the person is a minor or not,
That is
it's not done. Your further case is that this act was never amended, modified in view of the Prohibition of Child Marriages Act.
No, no.
Subsequently, the government decision, how it will be applied.
Well, then even in the list, that is in the concurrent list, the two registration and
You have
solemnization.
said that
No,
this
that-
is a list 3
Fine,
matter.
this thing, ma'am.
Okay.
Fine, highly oblige. My lord, interim protection may kindly.
The interim orders passed earlier to continue till the next
Fine.
date of list.
Oblige, highly oblige.
My lord, that's divorce.
Mr. Mahmood,
My lord.
your grievance was that your divorce talaq was not being registered
Not raised.
by the Kaji of that
Yes.
35. He is no longer there. You have the new act now.
No longer at present, but at that time he was there.
Okay, fine. It's gone. Today,
And
you have the,
my lord, may kindly.
no, I can't have a direction for a retrospective registration of your marriage.
No, no, that is, kindly say,
Hmm.
the divorce process was completed on 22/6/23.
It requires a compulsory registration.
Yes, compulsory registration, but thing is this, at that time he did not do this.
Fine.
This new act has come, repealing act has come on 16 March 2023.
And the allegation against you is that you had sent it by post. You had not personally gone to deposit that divorce.
Personally, we went, but he did not want to receive. That's why, my lord, it was sent, but that
It's
is
a disputed
that is a
question.
legal movement. By sending a registered letter, that is a legal process. So,
No, your registration therein would require your signatures also.
signature is there in the petition.
No, but in the register, you will have to sign. There is a format, you will have to sign. I forgot. I had dealt with one of such matters earlier. You have to sign in the register.
Normally, it is
By
not done.
sending it by email or by a post, how can you?
Normally, my lord, if we go to Baghdad Bhavan, it is not done.
No. Before the register, before the Kaji,
Kazi,
in his form, in his book, you will have to sign.
then the Kazi's role has been taken by.
Now
Yes,
there is a marriage and divorce register brought into operation by the new act. Why don't you approach before him? As per law,
By, that is district register.
huh?
District register or
Whoever it is,
family board.
no. Whoever the person is, whether your this thing is valid, invalid, that can be taken care of. But if you want to register it, it can be under the new act. You think over it,
Then in that view, I'll let the case be disposed of.
you think over it.
No, we have already thought some of our results should be there because since last 8 years, we have no connection. The purpose of marriage is totally frustrated.
Has anybody appeared for the private respondent?
No.
Mofida Khatun?
Just have,
Huh?
justice service was there. She did not get justice service that some person put their signature with mobile number. She refused to accept. That is there in the state, we have filed affidavit.
Where is your affidavit?
Yes, that was filed on 19/2/24. There is a signature of 2 witnesses with their mobile number. Can you see page 24?
I have seen. This is 3 talak, triple talak.
No, we couldn't, it is talake Hasan.
Awesome.
That means 3 times.
3 times.
months.
This is first, second, third.
Yes.
Talake Hassan.
Yeah.
But was there a mediation before that?
That was there, but it failed.
Where have you stated that?
That is discussed in Talaknama itself.
No, in your writ petition?
Very fiction.
Many times conciliations, please.
Reconciliation, yes, that is necessity.
Page 6.
Yes, that lordship may kindly see page 6, para 7.
Para 6 of.
Now, in the new act, what is the provision for registration of divorce?
District register, that is the district commission.
Lordship, some 11 and 12. That
Section 12 of the new act. It is whenever any marriage is dissolved or divorced, effected either by way of decree of a court of competent jurisdiction or otherwise, parties to such divorces may make an application to the jurisdictional marriage and divorce register for registration of such divorce under the provisions of this act within 1 month of such divorce being effected. So in that may be also required because I have a CRPF hospital right now. I am posted in Jharkhand. So she has filed large number of cases against me. So my duty is also suffering. I am dedicating for the country. Now I will fight with her or I will fight against the enemies. So matter is otherwise very crucial.
Your final divorce was, talak was on?
Yes, final talak was on 22/6/23.
So we'll have to, and the new act came into being force with effect from?
New act has come into force
October 24.
on 16/3/24.
No.
25, 10,
Yeah,
20.
no, this is the notification. This is the notification. Gazette notification.
Just now I have given the other matter. Item 12. 12, 13, 13, and stuff.
This is the repealing one.
Yeah, it is
Amara,
published.
that, 12, 12, 13.
This is, it has come into operation from the date
19 October 20.
at once. It has come into operation with effect from 19 October 2024, because it says it shall come into force at once. That means on the date when the governor has assented,
Yes.
1910. You have the 1935 Act with you?
1935, but you do not have, but in.
Marriage, 1935.
Section 9.
Oh.
Section 9 of 35 Act.
Print out UIDC. Print out the UIDC.
You have that? This one, it would have.
In our petition, it is in para 10, my lord. And reconciliation is para 4. So everything we have done, my lord. In para 4, there are reconciliation process that failed. And in 10, we have mentioned that section 9, Kazi has been given the power, but suddenly as it is abolished, the district director will have that power. And the marriage is totally breakdown. Since last 8 years, we have no correction.
He says both the bride and the groom has to appear. It's not required. It's only the applicant who has to appear. Okay. I had dealt with these matters when I was the standing council inspector of registration. Long back.
Inspector of registration, yes.
Director of land records. Okay. Heard Mr. M.E. Mahmood, learned counsel for the petitioner. Also heard Mr. J. Handick, learned standing counsel, revenue and disaster management department. What's up? None has entered appearance on behalf of the respondent number 4.
4.
Who is for 3? You are appearing.
No,
Sadar Kaji.
he is not appear.
None has entered appearance on behalf of respondent number 3 and 4. What's up? The petitioner has filed an additional affidavit with regard to the service of notice upon the respondent number 4 by way of trustee. Also, a perusal of the same reveals that the respondent number 4 had refused to accept the notice in presence of 2 witnesses. Also, accordingly, this court There is no acceptance of service of notice upon the respond number 4 by this court.
There is no action, but it should be presumed because justice service.
No,
was
there is
there.
a laujima. কি লিখিছো? Huh? So, full stop. Full stop.
In this case, lazima maybe this is not necessary perhaps because justice service is there. So she refused, but it amounts to service. As per order 5 rule 9.
Full stop. The Laujima court-wide order dated 22/1/2024. No. The full stop. The notice upon the respondent number 4. The full stop. The office note dated. No, the order of the Laujima court's order dated 19/2/2024 reflects that the notice, service of notice upon the respondent number 4 is complete. Full stop. In view of the above position and having heard the learned counsel for the parties at length, registry to list this matter again on 4/8/2024 for delivery of orders. I'll go through it once and then pass the order.
Perhaps it may dispose today already if your worship desires.
Okay, we will dispose it of on 28. I'll have to go through it once.
Then part had one.
No. Enough, only delivery of orders.
Delivery
I'll
order-
pass the orders on 28th. I want to just be sure,
Yes. That is the sir. Obliged.
because I'll have to give you a liberty to
Register.
that 1 month period. I'll have to deal with that. Let me just see.
Alright, sir. But if that new act, I already been doing.
Huh? The new act is there.
I.
You?
Some other matters also, ma'am, might be come also.
Okay, a copy of that, photocopy. She'll give you a copy.
No, I have my lot, that I
But-
have given to the.
Ah,
Public.
yes,
Item number 15, your lordship has already heard this matter, lordship, and.
but we
reserved
wanted
for-
to hear the matter further because of the, where is Mr. Das?
No, lordship, after that, lordship, one transfer order, the transfer certificate was issued against.
That is also under stay.
Yes, lordship,
Ah.
but this matter has not been listed today, lordship. This is the difficulty.
What is that writ petition?
1086 of the 2025, lordship.
WPC?
1086/2025, lordship. Lordship, can it be taken up on Thursday, lordship, it's not
Also,
inconvenient.
heard the learned counsel for the parties. Also, it is submitted at the bar that an analogous matter involving the same parties have been involving the same parties, that is WPC number 1086/2025 has not been listed. Although a direction was issued earlier for listing the said writ petition along with the present writ petition analogous. Full stop. Accordingly, registry to list this matters, list the present matter along with WPC number 1086/2025 on
Thursday, lordship, it's not.
Thursday will not be possible.
There was.
It will have to go to 31,
July.
July 31.
Yes.
Because we have fixed up many matters. 31/7/2025 for further hearing.
Give me a- Interim order is there, lordship, that may be complete.
Interim orders passed earlier to continue until further orders. Yes, Mr. Goswami.
My lord, I got my lord instruction, my lord, as also on the directed my lord.
Yeah.
Where is your, that master circular things? Prescription in the master circular.
They have imposed two manner.
You say irrespective of any trade of artisans categories, such as turner, fitter, machinist, the post of senior technician have avenue of promotion. So and so, 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 in order to be filled up, the post of so and so. How can you, where is that prescription, exact prescription? That the feeder cadre would be all trades. Because you have a very definite hierarchy. Did they both appear in the same suitability test?
Yes, ma'am.
Where can I find it?
Suitability test, no, my lord.
It's there. Machinist became senior most for the, and the post of so and so as filled up on the basis of suitability test. Is it one test for both the categories? Yes, Mr. Hussain, is it one test for both the categories?
No, no, madam.
Different tests.
Different, man. Different feeder, different category.
No. The suitability test, was it the same or different?
Different, madam. Definitely. That is why they, madam, the very purpose
No,
of
madam,
the
one,
making
madam.
combined list.
Wait, why are you giving me this?
Madam.
I had asked you very simple question.
Madam.
What is the
Feeder cadre.
feeder cadre for?
To, yes, senior practitioner, my lord.
As the
They have
feeder-
state, my lord, categorically that both.
No, they're saying will not do. I will have to have that prescription in your master circulars. You have IRBM, IREM, master circulars. These are the Bibles,
Yes, yes, yes.
Gita, Quran for the promotions
Okay.
in the railways. Where are those?
And my lord, the making of combined list, my lord, some extent it's clearly indicate that there is a two different feeder post categories, they depend. That is why just they merge it
Mr.
with a view to
Hussain,
give back.
Mr. Hussain.
Ma'am.
Tech 3, Tech 2, Tech 1.
Take one.
They may follow a particular category wise advancement.
Ma'am.
But once everybody reaches Tech 1, if they say these are amalgamated
Ma'am.
for promotion to senior Tech, what is the mistake? But for that, I'll have Mr. Goswami has to
Madam.
show me that.
That, yes, ma'am.
And my lord, one
Exactly.
SN Dash was from the
Turner.
Turner.
But-
Hierarchy is
but-
the Turner.
But
That is
I am given to
Sir,
understand.
sorry, Mr. Goswami, I
Just
want nothing.
first line neck.
I
railway
only
was
want
their post of
a
the-
prescription in law
My lord.
that for promotion to senior tech
Hmm.
or master craftsman,
Hmm.
the cadre of machinist, turner, turner, what is that?
Hmm.
Fitter,
Yeah,
these
no.
are all amalgamated. Finished. That's
Yes,
the end of the
yes.
matter. Just show me that prescription. Where is it written?
My lord, it is, my lord, in the, my lord, judgment of the, my lord, tribunal,
We are not with the trade because that is under challenge.
my lord, they have, my lord, accepted the fact that it was amalgamated, my lord. But, my lord, thing is this, my lord, I have said, my lord, that after, my lord, restructuring, my lord, they wanted, my lord, the tribunal has said that you give restructuring benefit, my lord.
We are not on that.
Otherwise, my lord, it is okay, my lord. If it is one post, my lord, this, my lord, Rabha is eligible, my lord. It is, my lord, stated in the order, my lord. If there is one post, then Rabha is eligible.
I
What
got it.
tribunal has
But
given,
this
my lord-
court is
Yes,
examining the issue
Yeah, yes.
on review. We want to know whether that conclusion is correct or not.
Whether there is one post. and
Not
both
one
did-
post. My case is, my query is that I have written it in the last.
Yes, ma'am. Yes, ma'am.
That what is the feeder cadre for the post of senior technician master craftsman?
Madam.
Whether it is trade wise or all the trades get amalgamated at the level of Tech 1. You have Tech 3, technician grade 3,
Hmm.
Mr. Goswami,
Yes, ma'am.
technician grade 2,
Hmm.
then technician grade 1. These are done category wise, turner, fitter, machinist.
Yes, ma'am.
Now show me that once they reach Tech 1,
One, madam.
they are all amalgamated for promotion as senior machinist or senior technician or machinist, master craft.
Master.
That much only I want.
Fine.
Thursday,
Malak, today is 22,
Friday.
25th.
Friday would be 25th. That's a 14 matter I can't adjourn, 15 matter I can't adjourn.
Yes, Malak, 25th.
Mr. G. Goswami, learned counsel for the petitioner, submits that he has received instructions in response to the queries raised by this court-wide order dated 15/7/2025. However, he submits that the same would not satisfy the queries so raised and accordingly prays that the matter be taken up on Friday, on which date he shall apprise this court with regard to the queries raised by this court-wide order dated 15/7/2025.
On the Malak, from the Malak, this menu is Malak.
See, in para 2, you have said feeder cadres for promotion to the post of so-and-so
Hmm.
is technician 3 from any trade of artisan categories. Now you come to 3. Come to your next page.
Yes, Malak,
Here, tech 3
Malak.
is 1,900 GP.
Tech 3.
1,900 GP.
Yes, Malak.
That is not a promotional avenue to senior technician. It is from senior technician that you go to the cadre of machinist, or sorry, a master craftsman.
Technician grade 3, Malak. Yes, Malak.
So you will have to be tech 1 first. Then you become senior technician. We are concerned with senior technician basically.
Malak. Malak, I'll get that answer.
There are 2 RB railway board circulars
Malak.
that you have not annexed.
Yes, Malak, I'll answer.
Only thing, what is the problem? I'm not concerned with restructuring. I'm
This-
not concerned.
These authority Malak letters.
No, no,
if they have indicated-
I don't know whether it is relevant. I want the relevant one,
Relevant one.
which shows that, see, for promotion to senior technician, these are the feeder cadres. If it is trade-wise, then Rabha could not have been promoted.
And
If the post was created in the Turner cadre, you can't create a post without authority for all the trades. If the requirement is that the post would be created in a particular trade, it will be created in that particular trade. Or show me, we will ask Mr. We'll dismiss.
No.
We'll allow the repetition.
The enclosure, the 2 enclosures, Lordship is not satisfied with those.
I'm not satisfied.
Yes, ma'am. But that's.
I'm not satisfied.
Yes. That- okay.
I only want to know whether there is a hierarchy maintained trade-wise, or it is a turner can go and become a fitter can go and become a machinist. A machinist can become a trade turner. This much only I want.
Yes.
No, my machinist, they cannot become a turner, my lord. But my lord, the my lord, senior technician, my lord, that post is for all, my lord.
That
Everybody
only
can
show
go.
me. That
But-
only show
but-
me.
But become the senior technician, he doesn't become turner, my lord. He'll be a machinist, my lord.
I got it, but just show me that the post of senior turner
The
or senior technician
technician.
is created irrespective of trade.
But-
That much only. That's, I
Yes,
think, the first query.
Yes, sir.
The council shall apprise this court to the trade for which the so-and-so was so created. Shall apprise this court as to the feeder cadres for promotion to the post of senior technician, master craftsman. I just want that.
Exactly.
Give me that.
But-
Full stop. Mr. Goswami prays that the, itu aku kini lagi sila tu. Oh? Mr. Goswami shall apprise this court with regard, shall apprise this court with regard to the queries raised by the order dated 15/7/2020.
This is when, again, my lord, this,
Ha,
right in finance, my lord, it's an autonomous institution. Lordship said, my lord, where is whether they have adopted the policy taken by the government. That is the question, my lord. My lord,
more particularly with regard to the statements made in
Well, in para 3, my lord, of
Just-
my reply, my lord, I have said
Just
that
a
is a
moment,
creation
just
of
a-
the state, my lord.
Page 3 of the affidavit file, para 8.
My lord, before my lordship proceed, my lord, may take 1 or 2 days time, my lord, for my lord, this clarification, my lord. I do not want to waste my lord time. My lord, my submission will be, my lord, I have already written, my lord, that is it's a creation of state, my lord. So, my lord, they cannot go against the policy
No,
of
you
of the state.
No, they have said clearly
Hmm.
in para 8,
Hmm.
second para. Para 8, second para,
My lord. Well, state government policy, they have said, my lord. That,
they have said we have never appointed anybody on compassion.
my lord, kindly see page 3, my lord. Page 3, my lord. The state government earlier produced the policy of compassionate appointment, which was discontinued in April 2007 due to obvious drawback in the policy, my lord. My lord, my application probably, my lord, before 2017, my lord. Next, my lord. So far, innumerable.
The
incident
said
of-
policy of compassionate appointment is not applicable in the corporation.
My lord, but they cannot say that, my lord.
Why?
It's a, my lord, organ of state, my lord. They cannot go against the, my lord, government policy, my lord.
Without a scheme, a compassionate appointment cannot be effective. Okay. Mr. G. Goswami, learned counsel for the petition, submits that he be granted 2 days' time to make his submissions, further submissions in the matter. Full stop. None has appeared for the respondents. Full stop. In view of the above, the registry to list this matter again on 28/7/2024 for further hearing.
29, my lord.
29/7/2025 for further hearing. Mr. Tiwari, what are you waiting for? Okay, lockout and strike both. Yes, Mr. Solomon.
For the last quarter, I was supposed to produce the records of the case. Records are evident. Please, Lordship.
What is the basis for the decision of the state level committee?
Based on some inquiry report, Lordship, that is reflected here. I have flag marked the relevant pages, Lordship, as indicated in the page, cover page.
Is it the patta that finally?
No, the caste certificate, Lordship.
No.
The basis of them, I not that,
There was a patta wherein there was some recording.
but that does not show that, my lord,
This enquiry report is not on record, I suppose. Enquiry report by the committee is not in the part of the writ petition.
No, my lord. His son of my lord, horror to my
But
lord.
is he still continuing as the
No, but
president?
that, my lord, he's no longer in the, my lord, the sub,
Ah.
but that certificate is still valid. Maybe he is enjoying some benefit.
Is he alive? Man.
Alive, my lord.
Anybody representing him? You're representing. Do one thing, we will not have a backdoor consideration. Let Mr. Sarania peruse this enquiry report, make his notes and make his submissions thereon. No, you peruse this enquiry report. You get my point?
One, provide one copy also, my lord.
No copy will be provided.
Fine.
You can make your notes.
My lord.
Full stop. Mr. Aram Das, learned counsel for the Aram Das, learned counsel for the
Social justice and empowerment.
Social Justice and Empowerment Department has placed on record. Has furnished the records pertaining to the verification of the caste certificate of the petition by the of the respondent number 7, seven by the state level committee. So on a perusal of the same, it is seen that the state level committee had constituted
ordered with it, what? Like number 6, Lordship.
A committee for verification of the caste status of the respondent number 7. And basing on the said report, basing on the report of the said committee, the orders in the matter came to be passed by the state level committee. State level scrutiny committee.
Caste Scrutiny Committee.
Caste scrutiny committee, the state levels caste scrutiny committee. Also, Mr. Sarani submits that he be allowed to make notes with regard to the conclusions reached by the committee constituted by the CS,
State level caste.
SL,
Yes.
state level CSC.
Scrutiny Committee.
State level caste scrutiny committee, state level caste scrutiny committee. Also, prayer accepted. Mr. Aram Das shall grant access to the records to Mr. Sarania and his colleague to peruse the inquiry report and make notes therefrom. Also, Mr. Sarania is thereafter permitted to make his submissions in the matter. The registry to list this matter again on, we are not giving you a long date. On 29th, we are taking it up. 29, right? 29/7/2020. Yeah, record to put it. You give it to him today itself. Yes, Mr. Industrial district sector.
As my lord has rightly pointed out, this is the case connected with the strike as well as the lockout. Now, my lord, I'll just present the substance of the case. There was a strike. And in consequence of the strike, there was a lockout. So lockout is the outcome of the strike and not vice versa.
Now, both
Now-
have been declared to be unreasonable.
I'll come to that. So since lockout was a consequence of the strike, now the question arose because the workmen raised a dispute, the union raised a dispute, namely as to whether or not the workmen are entitled to wages during the period of lockout. The reference was a subject matter of consideration before the labor court. The labor court held that a strike was unjustified as well as the lockout was also unjustified. Since both were unjustified, therefore, the labor court applied the doctrine of apportionment of blame, placing reliance on the Supreme Court judgment in the Statesman case, and said this is a fit case, wherein the blame is to be apportioned between the two, and as a result, the 50% of the back wages were awarded. Now, my lord, leaving aside all of the ground, there are multiple grounds on which the judgment of the labor court is under challenge. The foremost is, the judgment is contrary to the very mandate of section 18, subsection 24, subsection 3, section 24, subsection 3 of the Industrial Disputes Act. The section 24, subsection 3 mandates that if lockout is the consequence of an unjustified strike, that in such an eventuality, the lockout will be deemed to be legal. Now, my lord, the word justified or unjustified, this is not a term of law. The expression in the legislation is legal or illegal. My lord may have a look at section 24, subsection 3 of the Industrial Disputes Act.
Okay. Either of the lockout or the strike is declared to be illegal, then the other one would be legal. That basically is the underlying factor.
In fact, my lord, it's like the multiple layers of the onion. In the marine case, in fact, the Supreme Court outlined it beautifully. There may be multiple situations. There may be a case where a strike is justified and lockout is unjustified. In such a case, full wages will be full wages will be given to the workmen. They are entitled to the full wages. Strike, justified, but lockout unjustified, full wages. Now, strike, unjustified, lockout, justified, no wages. Strike, unjustified, lockout, unjustified, you apply apportionment of blame. But then the principle was applied by Supreme Court in a different situation. The Supreme Court envisaged a situation, and that was the situation in that case, where the commencement of the lockout was legal. To use the loose expression, justified. At the commencement, lockout was justified.
Because it
But
was in pursuance to the
because of
strike.
the prolongation of the lockout, and the evidence was on record to show that during the period of lockout, genuine efforts were made by the workmen to persuade the management to come to negotiation and to clear the deadlock.
Here,
But
there is a
management
finding,
did not do that.
here there is a finding that the management never,
The finding is perverse, which I will demonstrate.
that finding is perverse.
Thoroughly perverse. So there are various situations. So over here, the situation is strike is then justified. The
None is
moment you
appearing
say
for the respondents.
nobody. Mr. Ashish Dasgupta is appearing.
No,
But then-
earlier they were represented.
Yes, in fact, the case I believe came more than once. Yes, earlier he was. Today also possibly he will. So I'll explain the situation. So
No,
if
we
there's,
go ahead. If he is not there, then it will be a futile exercise.
because it will be good for the day, the case will continue for the
I
whole
know
day.
that, because if they are not there, why, what is the point in?
So possibly he knows that if I argue, I'll argue for the whole day. So he will listen to the argument and
But
then it will go
Mr.
to some other
Tiwari,
day.
the only thing that is to be considered here is, what would be the parameters required to be considered in a case wherein both the strike and the lockout has been declared to be unreasonable?
I'll put
The
it
word I
differently.
used.
No, again, I'll put it differently. If the strike is unjustified, ipso facto, as per the mandate of section 24, subsection 3, lockout is deemed to be legal. Now, if the lockout is deemed to be legal at the commencement, then you have to bring in the fact situation of the statesman case. Namely, you have to demonstrate that for a period of 2 years, when the lockout continued, the workmen made efforts to persuade the management.
What is the evidence to that? effect?
There is no evidence, there is zero evidence, this was not
No,
even argued.
evidence on your part that there were steps taken for
Well,
reconciliation.
it should be. Why
But you
should
had
we?
also declared a lockout.
My lord, there is no presumption. The very fact that the lockout continued for 2 years by itself would not lead to a presumption that it was intentional on our part.
Strike
Because
also,
it is they who are demanding full wages. It is they who demand full wages.
can you,
underline
can you
on
get Mr. A. Dasgupta?
Below the case which was
Mr.
not
Kulda.
argued.
Ask your colleague to sit along with Mr. Tiwari.
This was a point never argued. The issue never arose. Possibly, my lord, the London Labour Court had left orientation thoroughly in favor of the workmen and went on that with socialistic streak and then analyzed things on its own.
Because my cursory perusal was when I found that you are appearing, both of stalwarts are appearing. I said I should not be
Stalwart-
going deep into the
No,
matter.
This is not my field.
But what I find
I
is,
picked up.
I just am looking for a conclusion of the learned tribunal with regard to justification of the final direction. That fifth
Justification.
of the
I'm sorry.
final direction, 50% back wages.
Yes, there
I
is
just-
basis for that.
I just wanted a conclusion. What is the conclusion? Because he has both ways said the strike was, he has.
No, my lord, I
record-
asked myself,
Oh.
is this the case of the Labour Court? Because is this the case of the Labour Court that the fact situation prevailing in the present case is precisely the fact situation which prevailed in the statesman?
No, we'll come to the statesman case.
Unless and until, my lord, unless and until that happens, you can't apply the doctrine of apportionment.
I got it. I got it. Now, the
So
confusion.
where did he get it? It is nobody's case. It was never argued. He doesn't even touch upon that. He gives a short shrift to section 24 subsection 3. He just mentions it and moves away.
He does not go in deep.
Yes. And my lord, in fact, it is so badly flawed. The reasoning itself, there is
Mr.
patent.
Just for my benefit, can you just come to page 171, second paragraph?
Yes. Let us
Second.
now consider, it begins with that. Let us now consider, because that is in connection with the care beta case. Referring to care beta case, the court
No, no, no.
analyzes it.
Page 171,
Okay,
internal page 14 of the judgment.
171.
Just one page.
That's an educational program.
No. While, second paragraph.
While on the one hand, it has to be remembered that a strike is a legitimate and sometimes unavoidable weapon in the hands of labor. It is equally important to remember that indiscriminate and hasty use of this weapon should not be encouraged. It will not be right for labor to think that for any kind of demand, a strike can be commenced with impunity without exhausting reasonable avenues for peaceful achievement of their objects. There may be cases where the demand is of such an urgent and serious nature that it would not be reasonable to expect labor to wait till after asking the government to make a reference. In such a case, a strike, even before such a request has been made, may well be justified. The present is not, however, one of such cases. In our opinion, the workmen might well have waited for some time after conciliation efforts failed before starting a strike, and in the meantime to have asked the government to make the reference. It's neither here nor there. He does not know what he wants to convey.
Just go below.
Summing
Summing
up
up
the
the
materials
materials.
on record, it reveals that the declaring of lockout on such and such was unjustified. Now, my lord, I ask myself on what basis?
Proceed further to the next
The
paragraph.
educational program was started from 23/5/2009 and ended on 4/12/2010. The union did not ask for a solution from any legal forum and they indulged in the agitational activities. Therefore, the strike was unreasonable. Very well. In syndicate bank such and such, it was held that a strike is considered unjustified if it is found on unreasonable and perverse.
So,
etc., etc.
Mr. Tiwari,
Then a strike is unjustified.
sir, one factor. The fact position in, I've not gone deep into it. Fact position in statesman is that the court was swayed by the fact that the workmen were demanding a solution, reconciliation.
There can't be a misplaced sympathy. The problem is,
Here
it
there
is
is,
connected with the strike.
he himself draws a conclusion that the workmen were never interested for a
Yes,
solution.
that is precisely the case. From where does he get all this?
And with regard to lockout, he has,
My lord, here the entire fighting is perverse. It suffers from patent illegality and material irregularity. That is why it's a certiorari jurisdiction.
sorry, I got my things. Now you can proceed as per your style. Yes, where is
My-
Mr. Dasgupta?
That's in court number 14, my lord.
Let Mr. Tiwari continue. Okay.
So, my lord, better I start with the judgment itself.
Saranya, Senior Advocate Mr. Saranya wants the photocopy of the document. Can it be? Because it's a record.
That may not be permissible because it's an official document.
Yes.
We cannot.
Yes.
Let him make his notes only.
He can make the note.
Make his notes.
Yeah.
And when the matter is argued, you can always give him the file for reference.
Yes.
Yes, Mr. Tiwari.
So, my lord, I start with the award itself.
Hmm.
In extenso. The reference case has been initiated on the basis of a notification issued by the secretary to the government of Assam Labour and Welfare Department dispute white memo such and such dated dispute the 12th July 2017 under section 10(1)(c)(d) of Industrial Disputes Act 1947. In the scheduled portion of the said notification, there are two issues framed by the government of Assam for adjudication by this court. The issues are as under whether the management of Mrs. Assam Carbon Products Limited is justified in deciding lockout of their factory office at Bedpuchi, Guwahati for the period from 7/12/2010 to 8/3/2012. So this is the period 7/12/2010 to 8/3/2012. If not, whether the workmen are entitled for some relief against the said lockout. After receiving the notice, both the parties appears before this court. The workmen union first filed a written statement. Now, this is important. What the core of the written statement? What was our case? The case of the case of the union is that the management had declared the lockout of the factory of Mrs. Assam Carbon Products Limited, Bedpuchi, Guwahati 26, with effect from 11:30 p.m. of 7/12/2010, while notice dated 7/12/2010 on the ground of financial loss. So financial loss was also one of the relevant factor. As to why financial loss was there, I will show that. Financial loss is stroke production, and it was due to indisciplined acts, go-slow tactics, sudden strikes, disregard to the direction of the management resulted by the Assam Carbon Workers and Employees Union. It was also stated in the lockout notice that the workmen had blocked the road on 4/12/2010, leading to factory and paralyzed the operation of the plant by shouting slogans. They also threatened the executives and restrained the willing workmen from entering the factory, and on 6/12/2010, the workmen remained absent. The management was not in a position to control the situation, therefore they compelled to declare lockout. The union had appealed before the management for raising their bonus for the year 2007-8, 2008 to 2009 to the workmen. But the management did not fulfill the demand. The management also violated the terms of memorandum of settlement. The lockout is unjustified as because there are provisions for tackling the situation to maintain peace in the establishment in Industrial Dispute Act 1947, the Payment of Wages Act 1936, and the Industrial Employment Standing Order Act 1946. Therefore, for the workmen, the lockout was unjustified and they demanded a war in their favor. The management replied the contention of the workmen and also placed their case before this court in the written statement filed by them. According to the management, the workmen had been adopting concerted go-slow tactics and did not heed to the request made by the management, requesting them to cooperate, the management, and also to increase the production as per the NPC norms. On 16/7/2009, when an attempt, pausing here I clarify, increase the production as per the National Productivity Council norms, this was also part of the memorandum of settlement. It was part of the tripartite
It was a
settlement.
tripartite settlement. Section 18 tripartite
In
settlement.
fact, there are two settlements. I'll come to all that. This lockout is not a single lockout. Previously also there was another lockout. In fact, the trouble was continuing since 2008. I'll explain all that. On 16/7/2009, when an attempt was made to take out the finished products from the factory, the workers obstructed it and they physically assaulted Shri Vikramjit Goswami, who took photograph of the situation. They also assaulted physically Shri Anupam Goswami, who came to save Vikramjit Goswami at that time. So there was physical violence also. The management suspended few workers for the incident that occurred on 16/7/2009 after conducting domestic inquiry. An FIR was also moved before the officer in charge of Chanmari Police Station on 20th July 2009, requesting the police for patrolling duty in the area. On the same day, an appeal was made to the workmen to maintain discipline and harmonious industrial relation and environment, and it was agreed upon that the tripartite settlement dated 20th July 2008, it should be 23/7/2008. I think there is a error of date. Anyway, I'll check that up. That the tripartite settlement dated 20th July 2008 should be followed. Having found that the go-slow tactics was still on the management, while the general notice dated 8/8/2009, management warned all the concerned workmen to stop go-slow tactics and to restore normalcy of operation. But the workers did not respond. They rather continued their agitational programs in the form of dharna, slogans, hunger strike, tool, pen down strike, etc. The workmen decided to go for mass casual leave with effect from 9/11/2009 and tool and pen down strike on 13/11/2009. On 4/12/2010, the situation became violent when the workmen came to the factory gate and restrained the staff and other workers from entering into the factory. In this regard, an FIR was lodged by staff bus driver.
I'm only hearing, I'm not now, without hearing you, I will never dispose of the matter. Or you want to be there when the matter is being argued by Mr. Okay.
You know, at the most, it will be part heard, what more?
No,
It
but
can't
he
be
will
more
also have to have the feel. He'll also have to have the feel of your.
My sister may take down the notes.
No.
I am not interested. That is, no, sorry. If this is the acquisition, I will not argue. Then I will not argue.
I'm also not taking it up. Mr. A. Dasgupta, learned senior counsel, appearing for the respondents. Oh,
My lord wanted to hear, so I started. Otherwise, I would not have. What, we are.
Mr.
So my
Dasgupta?
lord wanted me to argue, so I started.
when do you want this matter? I'm not taking it up because of the allegation. I'm not taking it up. You have it argued any way you want. We are not.
That the case is going on. Even the dictation is.
See, normally when the senior is not there, the juniors take the lead.
Tender.
She was here, I requested, we waited till she came. It is only after she came that I asked her whether we can permit Mr. Tiwari to proceed. Thereafter, she consented, then I allowed Mr. Tiwari to argue.
My lord, it can only be after 19th August, because next week I'll be. in
Whenever
Chennai.
it's there.
After 19th August.
Mr. P.K. Tiwari, learned counsel for the senior counsel appearing for the petition, and Mr. A. Dasgupta, learned senior counsel appearing for the respondent. Mr. Dasgupta submits that he is in the midst of a parthead matter, and accordingly is that the matter be not taken up today. Matter be not taken up today. Also, prayer is not objected to by Mr. P.K. Tiwari, learned senior counsel appearing for the petition. Also, accordingly, raised it to list this matter after 3 weeks on a date to be fixed by it. Fixed by it as per the list of the matter after 3 weeks as per roster on a date to be fixed by it. No issue. Statesman, just for my information, statesman is the law
Yes.
in this connection.
On apportionment of blame, of course, in statesman followed marine case.
Marine
The
case.
earlier judgment of the
So
Supreme.
for, if I have
But
to
it-
understand, I'll have to read
it-
marine and.
Yes, it expanded the
Yes,
horizon.
Mr. Dasgupta, for my understanding.
Statesman expanded the horizon, calling it a twilight zone. But then the
Hello, you.
Going on.
statesman may not, the Supreme Court expanded the horizon.
Okay.
That's
This is for my information. If I'll do well, judgment.
My friend is asking, since we have collected all the judgment, if my lord is so keen, we can very well.
No,
show the judgment.
no, I don't want it.
Not necessary.
I don't want it.
There will always be another day, my lord.
Another day. Mr. Dasgupta, you can do. All right.